First part of the talk is how do you protect the stuff that you create, the stuff that you have made and you broadcast or cablecast or cast wherever you want it, where your rights come from. It's part of the Constitution. It's not part of the Bill of Rights or the amendments. That was secondary. This is part of the Constitution itself, Article 1, Section 3. There's no quiz, it doesn't matter. And then the next part is how do you use the stuff that belongs to somebody else, and either it's okay, get away with it, it's free speech, it's fair use. I want to make sure we talk about fair use for a good 10 minutes toward the end, because that's kind of the domain where you guys should be. Right? Ready? That worked. All right, and this is a repeat of what I just said. Licenses and contracts, permissions. Are you familiar with copyright? Some of you, a little bit. Any of you been sued? No. Anyone register copyright? Pardon me, you have?
No, I've not been sued. I don't want to.
Oh, no. Let me, there is I'll get to it later on, but there's a new forum, a new arena for dealing with copyright disputes that is in the cheap to free range. Filing a case is not thousands of dollars, it's under $100, it might be $40. It's the CCB. I'll get to that. I wrote a handout that may or may not have been distributed. May not have been, apparently. We should get it to you. Maybe it'll get posted somewhere, so you have a good review of all the stuff that I'm going to talk about. And then there's some other stuff that I want you to know about. We'll get to that in a minute. Great. So, copyright protects creative works by original authors. Anything that you create, whether it's saved on your computer or put out by one of these things, is you have a copyright interest in it at the moment that you create it. The logo for the Copyright Office is a pen being lifted off the paper to suggest that you own something as soon as you create it. That means that if you are filming something that is interesting and you set it out free like a live broadcast on Facebook, you have a copyright in that. I'll teach you how to make that worth money or how to exercise some better control over it, but don't be fooled by someone saying you don't own that because you put it out for free. That's a lie. You own it, and you get how you can control it. I'll teach you some things about how to control that a little bit better. Copyright lasts for your lifetime if it's an individual, plus 70 years. That means that you'll be dead, and the copyright lasts longer than you. If you do it for a business or in a business name, then your copyright lasts for only 90 or 100 years. Again, you'll be dead. Most of you are not going to make it another 100 years. The point of that is that's true of the stuff that you find out there online or in the world, that it likely belongs to somebody else. And I'm gonna break your heart on something. The internet has not been around that long, so just because you find it on the internet doesn't mean it's free to use because I found it on the internet. Finding it on the internet is not the same as finding a lost manuscript that's been buried underground for 100 years. As a rule of thumb, given how long copyright lasts, anything older than 1925 is in the public domain. Things are not protected by copyright, or no longer protected by copyright, or were never protected by copyright, or in the public domain. That means it's free for anybody to use. The domain of the public. We good? And the rights that you get with a copyright are the right to reproduce it, distribute it, create derivative works, public display, and perform, which kind of pretty much covers everything. Under debate now is under reproduction and distribution and derivative works is the little discussion early on about AI. How is artificial intelligence? Does that mean that the computers have collected stuff from places and put it together and created something else? Depending on your school or your camp or wherever you are, is that a derivative work? Is it a copy? We're figuring that out. We, the people, are figuring that out. No good answers yet. Infringement is when you don't have permission to use somebody else's work, unless it falls under fair use. And for just as a general reference, the copyright law is under Title 17. Section 106 describes the rights of what you own with a copyright. Section 107, which the last time I looked is right after 106, describes fair use. The times that you're not only allowed to, but you are entitled to use somebody else's work in particular ways. That's where news reporting comes in, and scholarly work, and academic work, teaching. All of those are in the kind of the preamble of fair use. And then the fair use law, which is a feature. People will tell you, I'm on the podium now, people will tell you it's a defense. Bullshit. It's a feature of the copyright law. It was anticipated in the writing of the copyright law that you will be allowed to comment on, to respond to look at work, look at stuff that's out there, and put your spin on it and transform it into something new. We'll talk about it. Good? For example, because you guys work in visual images, the technology changes things. It changes the rules. Copyright is changing. 1909, there was no movies. There were no, the first registration for films were a stack, and a very large stack, of still images that were stacked up 24, well, it was probably more like 18 frames per second back in the day. I think it was Buster Keaton's The General. The reason we have such good copies of that is they were all still images, stacked high, that number of frames per second. Just throwing that out there, and because I like that picture. And because of the day, this is a reminder that it covers characters, machines, lands, Yoda, the copyright covers all of these different spins that you can do and extract from an existing work. Now, how did I get permission to put this in my slideshow? I'm teaching. It's fair use. And they don't want to mess with me anyway. Although now they have the Force. They had the Force in this picture. Now they got like Darth Vader and the Hulk and Iron Man. They're all on the same side, so they're a little more formidable to mess with. And we'll see how that works out for the governor of Florida, because that's who he's fighting with. I didn't change this. So the next thing that you need to know about copyright is it's only for people, humans. Now, you might laugh thinking, why would that ever come up? That it's only for humans. Well, believe it or not, the Copyright Office had to write special rules because people were claiming copyrights in work done by macaques. This photographer set up a camera, and that is Naruto, for those who didn't know. Naruto is a macaque, and he was really taken by the iPad and allegedly took photographs of himself that were very popular, and they tried to monetize it, claiming that the macaque, Naruto, owned the copyright in it. and the Copyright Office said, no, animals don't own copyrights, and this might not come up for you. You might not have anyone putting a camera on a cat or a dog or a monkey or a squirrel or a rabbit and passing those photographs around. But believe it or not, it happens, and it gets a lot of hits, and there's a lot of money in it, because once you hit a certain number of people paying attention to the work you're doing, I don't know where the line is, 20, 30, 40,000, all of a sudden Google or YouTube or people will get a hold of you saying, hi, would you like to monetize your audience? Have anyone had any experience with that? Not yet? Oh man, you're probably all government channels. I apologize for that, sorry. So this is just, pardon me?
You're not wrong. You're not wrong.
Yeah, I'm sorry. Well, government is entertaining. You just need to have the right attitude about it. And I'm a copyright lawyer, so I think government is entertaining. You guys have to look at government as, well, that's where my money comes from. I got to be careful on what I say about it. But given if it's government, they don't have a copyright in the work that they create. If they say something entertaining, I bet you don't have it's easy for somebody to take something and use it in particular nefarious ways. Copyrights, these are the rights, it's a repeat. Sorry, I had to cut down here we go. So here is about the extension of the law and why this is interesting. It's interesting because in 1998, the copyright law was extended for 20 years because Congress, in their infinite wisdom, didn't think the internet was going to be much of anything. What would you use a computer network for? Well, they were wrong. And Mickey Mouse was set free in 2019. And what that meant, that the original registration of the copyright in Steamboat Willie is no longer effective. And the only aspects of Mickey that are still protected by copyright law are the ones that have been added by Disney slowly over the years. So this original black and white Mickey is free for you to do whatever you want. And if you're not sure, fans of John Oliver in the room? So did you see the piece that he did about Mickey? I suggest that you look that up, because I couldn't possibly make the point better than he did about what you can do to Mickey now and other sacred things that we consider important and sacred in just mining what is now the public domain to talk about. I know this is not good for the government people, but for everybody else in the room. And you train videographers, you train people how to use the media, how to use these tools, how to deliver a message efficiently and effectively, right? That's what we're about, more or less. I will show you in a minute what, not me, I don't approve of it, but what was done to Winnie the Pooh and Piglet. Who has seen that movie? Well, you see the trailer? Did you see the actual movie? No. You might not get a chance to see that movie because it was just horrible. It didn't get, I think it's the first time that Rotten Tomatoes was really appropriate. And it is creepy, and it is wrong, and it is free speech and fair use, and if they can't take a joke, that's too bad. Repeating, you own the work that you create unless it's a work for hire. Work for hire means, and it would have to be written in your contract, that this is a work for hire, It has to be very clear. And under the copyright law, if you're not allowed to, well, you're not supposed to be able to fool the artist into, oops, you gave up your rights, sorry, fooled you. If it's not clear that your rights are given up, if the words work for hire don't appear in your contract, unless it was you're working on a movie or you're working on an answer key, there's 5 or 6 exceptions where it is a no duh. You never own the rights to that artwork. Unless it says work for hire, you as the artist, as the filmmaker, as the photographer, as a sound person, as the recording engineer, you own the copyright. And you might say, Cole, I don't understand. How could that ever come up? I don't know. You could call Taylor Swift and ask her why she had to record all of her original recordings because she gave up the rights in her master recordings to some unnamed person. I'm not, no names. And she just recorded everything because she didn't have the rights to her original master recordings. For those of you who don't do music stuff, the master record, when you go into a studio, you make a master tape, and that's what gets worked on and polished up and made appropriate to make DVD, CDs, digital, whatever it is, get the final. But the masters stay in, I guess, technically a vault somewhere. But Prince's estate still has a vault of all of his master recordings. If you're into this at all, you can read about how artists have kept their master recordings separate and sacred, and otherwise, if you lose control over them, I could go on for about 2 hours about really interesting battles that have been happening with master recording people competing with the living artists now. So, read those contracts too. Don't step into a studio, and I don't know when people do work in your studios whether you have any kind of discussion about, by the way, who owns these master recordings, where do they go, how are they preserved, what are your obligations to preserve them, does it matter or not? A lot of times you don't know how interesting or how good the people that you have in your studios. You're familiar with the lore about who started out in public access and then developed very successful careers. Anyone want to throw out a name?
Ted Turner.
Pardon me?
Ted Turner.
All right. Yeah, Ted Turner, that's one. Jerry Seinfeld is one. Excuse me? Yes, yes. It's hard to spell, but yes.
Rogers?
Well, Mr. Rogers, did he start on public access or was he public broadcasting?
Yeah, public broadcasting.
Well, I don't know. It's all the same. It's public something. But, right. But and Mr. Yeah. So you don't really know what you have and how good it is. So take all of those things seriously and preserve them, although now digitally it's much easier to give somebody a good copy of whatever it is they're working on. I made that point. For the creators of content, I highlighted, you can't see the highlight at all, reminding everyone to keep the rights, I call it the portfolio rights. Oh. There we go. Keep your portfolio, keep the right for you to show the work that gets broadcast or cablecast or cast wherever, that you want to be able to keep the rights to those things to promote yourself going forward. Don't give up all your rights. This is true for artists, for fine artists, for musicians. Keep the right to you keep control over that yourself, even if you give up the rights to pass it around and cablecast it. You want to be able to keep that on your website. We don't know where all this is going to go. If we dial it back not that many years, there was like MySpace, where people would put their own recordings. There's there's more than I could possibly keep up on. But the idea is that you want to help people preserve this and to promote themselves, because it would be interesting. We don't know how interesting all this is going to be in the next 5 or 10 years. And now I want to talk about copyright registration, because none of you have done that. It's worth looking at to see what it takes. Copyright registration is important. Even though you own the copyright at the moment of creation, registration gives you tools to enforce your copyright. Tools would be, with a copyright registration, you have the legal presumption the work belongs to you. Oh, where we go. Well, let me dial it back. I'm sorry, I'm confused. I got 2 slides at once. Copyright.gov. Don't be fooled by the .com or .swat, whatever dots come up. .gov means government. That's the right one. There are .coms that are the wrong ones, and they will maybe do something. They might not do anything. They will certainly take your money. .gov, and then ECO is the Electronic Copyright Office. It's worth looking at and opening up an account. It costs nothing. Open up the account and look to see the kind of questions that they ask you about a copyright registration. After you fill out your registration application, the next thing they do, after that's done and you have a chance to edit it and make it right, then they want your money. Not before. So if you get it wrong or you don't want to pay, start another one. Throw it out. They don't care. And then the last thing is uploading your deposit, what it is you're sending in to be registered by the Copyright Office. Over the last couple of years, it went from please do it, it's cheap, to now it's $65. But if you have a video that is important to you, that you're concerned about people hijacking it or using it for purposes that you do not approve of, registration is cheap, and the level of aggravation that you get to control it's invaluable, meaning it would be very valuable to you. That's all I can say about it. I've never had anybody sad that they registered to copyright before they sent in a movie, they sent in a screenplay, they sent in a 900-page manuscript to a book publisher. I've never had a book publisher say, "Oh, you registered the copyright, screw it, we're not publishing your book. We hate you now." Never. Because what it does is gives them some insurance that if a book does get hijacked along the way, that you have a stick in the ground and your presumption that the work belongs to you is effective then, from that point that you filed your registration. First in time matters. I won't say anything else. Oh, there we go. Everything I just said. Oh, the other thing is, if somebody does mess with you after you file the registration, you can get your attorney's fees paid if the court sides with your case. You can get an injunction. You can stop somebody from doing something that you don't like, using your work in a way that you don't like. Why? Yeah, I won't go into it, how people use work that you don't approve of. You send a cease and desist letter with some real teeth in it. By real teeth is you can essentially stop a Hollywood movie from coming out. You can stop a movie that's one of the Batman movies had some artwork in it that may or may not have belonged to Batman. It was appropriated from somebody who has done some art that kind of accidentally got sucked into a Batman movie. They stopped the world premiere of that movie until they got this resolved. As a good bargaining point when you want to stop a multi-million-dollar movie from hitting the screen, say, oh, you forgot to pay me, and now you've blown me off, and now I'm going to stop you. That was true for the movie, Terry Gilliam movie, 12 Monkeys. I won't go down all of those, but there are a lot of interesting cases. A movie, The Devil's Advocate, that got stopped because they forgot to ask the artist permission to use their art in the movie. Things settle pretty quickly on the courthouse steps when you have that kind of control. Questions? We good? Yeah.
Well, I do have a question. We had recorded a group, a musical group, just a local group, and for years, and they were in a lot of different other things, and on and on and on. Well, a few years ago, a different leader, conductor, whatever, took over that group, and he emailed us and said, you cannot and will not and should not play any of the stuff that happened prior to me coming, because basically it sucked and we don't want you to. And so we backed down, but can he do that? And what if, like if we just went ahead and started playing some of that old content?
Hang on, you got like 3 questions in there. Once it's 3 questions deep, I have to come up for air. Can he ask you to stop it? Yes, he can. Do you have to listen to him? No.
Why does he have to? Why can he tell us not to play the old stuff that he wasn't even a part of?
It's free speech. He can also tell you to jump out the window and fly around the Capitol building, and then throw eggs around. People ask for a lot of things that they don't get. That would be one of them. Say, I'm sorry that you didn't show up to the band earlier. That you're breaking my heart. Pete Best is pissed about it having left the Beatles. Wait a minute, that should have been me. Too bad. Why don't you get a lawyer and we'll make fun of him too. It's people can say whatever they want to say. That doesn't mean anything. It's free speech, opinion. I don't know anything more about that specific situation, but people can ask you to do things, and you go, no. Now, the next thing is, what rights might he have? I don't know without your rights to put that stuff out once it was in your station's hands. My guess is once it's in your hands and you've been distributing it for years, I'm sorry you don't like that anymore. You're breaking my heart. Let me get out the world's smallest violin and not play it for you because I don't care. I'm sorry, I drove that into the ground. Yeah.
What about the songs that band played?
Well, what about those songs?
Are those covered by copyright?
Well, yes, they are. But so music, for you music fans, there's been music for a long time. Not just in this country. There's been music for probably the last, 200,000 years. Music had, the first job of the, not called the censors, of the people before there was recorded music, there'd be ushers going up and down the aisles of a music performance. So I'm dialing it back to maybe the 17 and 1800s. Their first job was to make sure no smart-ass Mozarts were down there going, I'm going to make a recording, and write down all the notes and make a recording of that music, the charts. Their first job was to prevent that from happening. They'd smack them with a stick. There are the copyright in the charts, in the written music. There's a copyright in the lyrics that's separate. There's a copyright in the sound recording done by the original author. There's a copyright by anyone that covers that song later on. Part of the reason you want to register your copyright in either the charts or the sound recording or in the lyrics is so you have some control over it. Before 1989, now, because it's way after 1989, I used to say that and it would be a big deal, but now there are people that were not born in 1989 in the room. Before 1989, you need to have registered your copyright for it to be, once it was out in the world, public domain. You blew it. It's over. Now you have a presumption the copyright belongs to you because that's the way the rule was in Europe and in the EU. So if the copyright's not registered for old music in the charts, then you didn't have copyright protection. So the recordings that this band made of those songs, if they were not registered, then arguably whatever it is that this recording is, it's in the public domain. They can't put the genie back in the bottle. If it was registered, or if the copyright is, and I don't have my notes in front of me for those folks at home and might listen to this recording. I've had a lot to drink and everything I say is unreliable. But in terms of those recordings, one of the problems that you have is the band that put those recordings out, they no longer can control the copyright, which is not registered. Once it's in your hands, if they didn't register it, you can't reclaim the copyright for something that's out there. They can, however, if it's more recent than that, they can make it challenging going forward. Am I just making nonsense? Is this making any sense to you? It's so for this person that's complaining that the band that recorded these songs and played them before, he doesn't want them out anymore, too bad. What he could take, well, you want to do a better job now, give us better versions of those songs with a better band, and we'll play those, and people can compare them, see which ones they like. An interesting story about the charts, the recorded music, and once we figured out a way to have recordings, maybe the first one might have been the Gershwin piano rolls, that there were ways of having music played back without a person in the room. Then you can have different people covering different songs, so they could get the music and play it and perform it, and they would be different. Back in the day, the radio stations claimed, the music, nobody would go to a concert anymore. No one would go to see live music because they can get it for free on the radio. Why would you do that? And yet we still have concerts. We still have live music. It still matters. And if you're a Grateful Dead fan, and actually a little early in the day for a Grateful Dead fan to be awake, but for them, every recording of every song that was ever done, it is different and worth preserving, and they will debate. I went to a scholars conference, Grateful Dead scholars conference, and they debate about this concert and how it is different from the concert the next day, and the concert 2 days afterwards, and the concert that was in California versus the concert that was in Germany. It was very interesting. At one point, Leonard Cohen, who wrote Hallelujah, in the top 50 songs on the country, his own recording of his song was 45. There were two other people covering that song that were in the top 10 that were not him. and there's a documentary about him and the song Hallelujah, and he was amused by that, but not unhappy because the music and the sound recording have different income streams. So if you write a song and then somebody else sings the song, you split the money from it 50-50. So while other people had the number 5 and number 1 song, he got paid for every performance. I'll stop. Interesting? No. Yeah?
Sure.
Did I answer your question?
Yeah.
Great. Thank you.
To clarify, I have a video that I've created. I've already posted it to the internet. You're saying after 1989, you can go back and retroactively copyright it since you're the original poster, or?
No, at this point, if you have, you can't you can't capture it again. If it's out, and it's in the public, if it's publicly available, you can't recapture it. It's in the public domain. You need to. The laws changed over probably 10 or 15 years over what you could do and how long you had to correct it. I think the last time I looked, you had 2 or 3 years to try to capture, to register a copyright if it was released to the public before you registered it. I don't know where that is now because we have the tools to throw something out into for everyone to see it. It's harder to regain control over it. If the recording was never aired, it was never made public, then you can register it now because it was not out. It was not published. That's the word that people used. It was not, by published mean made public. Once you make it public, once you published it, then it's hard to get it back in the can. And especially now with the internet, once you make something public, it's published, you're screwed immediately. Oh, I'm sorry. It's just hard to keep control over it. But what it should motivate people to do is, if you think it's something cool, you register your copyright first. And I think there was an adjustment to the copyright law with sound recordings that allows you to do 10 in one registration now. Part of, back in the day, and this is not that long ago, the way you made recordings was you need a master tape, master recording, and then record pressing. Very few people had the ability to press their own records. Vinyl. You probably know people now who are doing it, but it wasn't that long ago that's how we would control distribution of music because it was impossible. Then tape came out, and it was possible to pass on recordings on audio tape, and then you dealt with the old cassettes and the fidelity of those cassettes versus the fidelity of a enhanced digital recording. And now we're back to vinyl being a big deal again. But sound recordings before 1972, up until recently, were not protected. Now, how does that play itself out in today's reality? There was a case, I gotta watch my time. There was a case a couple of years ago where somebody was accused, not somebody, it was Pharrell Williams and Robin Thicke, over the song Blurred Lines. And Blurred Lines was a song from Let's Get It On. For those of you, maybe that's the song, I don't know if I remember it, I didn't review it. So, because it was a sound recording that was made before 1972, the only way that they could, in court, prove that somebody copied the song from somebody else is into the courtroom. They brought a piano and Pharrell Williams to play live the music. So they had a musician playing the one song and playing the other one, and the court, the jurors got to decide whether it was a copy or not. That ended up costing Pharrell Williams and Robin Thicke a lot of money. I don't know, ignorant jurors. Today, Ed Sheeran had a similar problem over the same song where he was accused of copying the song, and again, because they didn't use they couldn't use a sound recording to compare the two pieces, Ed Sheeran had to perform in court his version of this song, and so the jurors could go, that's not a copy. So he won that case. I think it was reported today. So in terms of copyright law, and is this interesting, and do we care about it now? Is it dynamic? It has sucked me in for my whole professional career. Wow, this is interesting. So now I want to talk about using work without permission before I blow my time. You own all these rights, and you have control over reproduction and creation of derivative works and using it in all particular ways, but balanced against the monopoly right to control copyright interests is our right as we the people, citizens, to respond to things that we see and hear, to make our own interpretations of it, to again, Section 107, fair use, free speech, free expression. Those are very important ideals, and it is somewhat unique to this country. When we talk about First Amendment rights, First Amendment in our Constitution, a lot of countries do not have those kind of rights. We have them, and in order to preserve them and keep control over them, you guys need to encourage people to have people make stuff and respond to it and react to it. Political commentary is cool. This is Shepard Fairey taking a photograph and turning it. He transformed it into a artwork where, in case you're missing the subtlety there, he added the dove and the rose. That is a fair response to copyright in a photograph. Fair use. I don't want to spend too much time there. Let's talk about this. So where does it come up for us is it's not about the wall, it's not about the graffiti wall on this particular building, but what if I told you that car companies, to try to sell their cars as hip and cool for people, maybe the company's Mercedes, I don't want to disparage any particular car company, they photograph their cars in front of graffiti walls to try to show people under 70 years old that they're hip and groovy and they love art and street art and spend $90,000 on a car, please. In cases like that, car companies need to get a license, they need to get permission to use the art in that commercial way, and that would also be true of stuff that is produced on your channels, on our channels, to what kind of control can you have over how people use your art and the stuff that you put out there. It's a little more subtle when you're talking about school board meetings, but it still can be transformative. So I don't want to waste too much time. News reporting, commentary, scholarly work, educational work. The point is to take the essence of that work and comment on it. Look at it as a free speech fair use discussion, and not necessarily about copying it. Where that line is, it's lately it's been on a case by case basis. Um, Find somebody that knows something about it and talk about it and see where that line is. I would suggest if you're using somebody else's art, think about why you're doing it and why it's important and how you're commenting on how you're transforming the work that you're borrowing from in order to create your work. So, without getting too cynical, Mickey, who's everybody's pal, and now more than ever, but all of the big Disney movies, I think all of them or most of them, come from work that was in the public domain, come from old stories, and they put their version on it. And then Disney, now they're better at it, but in the beginning, Disney was a little confused about, well, they own Winnie the Pooh. Well, they own their version of Winnie the Pooh. They own The Little Mermaid. Well, they own their version of The Little Mermaid. They own certain things, and they don't own everything that they wish they owned. And this is a comment by my friends at South Park. There you go. I think that says it all. And now back to something that you saw earlier. There's this. Um, um, this movie came out this last year, Winnie the Pooh, Blood and Honey. And without getting into the plot at all, Winnie the Pooh and Piglet were abandoned when Christopher Robin grew up and went away. Perhaps this is a story about don't grow up and leave your toys because they could turn evil. And Winnie the Pooh and Piglet grew up and they just created a lot of mayhem. I can't recommend this movie at all, but it does make a point. It's funny. These are the considerations of fair use. It's worth visiting these. This is all under Section 107 to go back and see how it is when you're borrowing from somebody else. What do they consider? You know, who you are, how you're using it, how much have you taken, and the effect on the market for the original work. And that this is a very interesting conversation now, and we're going to find out, was it May, in the next couple of months, how this particular assembly of people that consider themselves the Supreme Court are going to decide what to do with the Andy Warhol and Prince case. I'm not going to go there unless you beg me. I have to talk about that. Whoops. Oh, look, I put some animation in. Sorry about that. Parody. Keep an eye on what is transformative. I don't have. How am I doing? Oh man. Parody is interesting. I made myself a note earlier. I think in August, in this town, at the university, or near there, there will be a screening of a film called Earth 2. You're not going to see any or much promotional material might through the university. The movie is called Earth 2, Earth II, like Earth 1, Earth 2. What this group of people, filmmakers, have done, they are incredibly talented, probably way more talented than they want to be. And they have taken from perhaps 20, 25 big commercial films in which the Earth has been um, under threat of destruction by either aliens or natural disaster. Not clear. And they have appropriated from, you'll recognize all the characters. Seamlessly, they've created a whole other story about the end of the Earth and how it's going to be, period. It's a very interesting exercise in appropriation. You will, if you go, you'll leave the film wondering, I don't understand how they got away with that. It's very impressive. Some of the best editors you've ever seen. And you'll see characters like Matt Damon and Will Smith over their whole film career, and the different scenes are appropriated in really interesting ways. And the question is, was that a fair use? Is that fair? As far as I know, zero effort has been made to stop it. Interesting. Have any of you heard the Grey album? No. Man. So, Danger Mouse mashed the Beatles' White Album and Jay-Z's Black Album and made the Grey Album. I strongly recommend you listen to it as an exercise in, this is how fair use, how you can transform two very recognizable albums into a mashed, a combined piece that is, and at this point, with copyright, if you don't bring a lawsuit, an infringement lawsuit within 3 years of the time that you knew or should have known that the work was infringed, you're barred. You can't bring that case anymore. This was done so long ago that you guys don't even know about this. I recommend it. It's enjoyable and interesting, unless you're offended by the Beatles album being mashed or the Jay-Z's album being mashed. If you're offended, that's not my problem. But it's really interesting. And another point that I want to restate is the substitute for the market for the original work. That's what seems to be key in the Warhol case. I listened to the Supreme Court go on and on about to substitute the market for the original. Did you know about the Warhol case? No, not at all. Okay. A quick version of it. Do you know who Andy Warhol was? Well, that's good. So before Purple Rain came out, before Prince was known as the Prince that you may or may not know, I think it was Atlantic Magazine, was writing an article about this new musician from somewhere in the Midwest, one of those flyover states. I'm sorry, well, we're in Wisconsin, so you guys can handle Minnesota jokes, right? The photographs of Prince were not enough to get the attention of people when the magazine was on the stands, so they had him photographed by a photographer that did rock and roll photographs, and then they gave the work to Andy Warhol to do something interesting with it to attract attention. Because when this article came out, Andy Warhol was a thing, a big deal. They made the poster, the magazine sold well, Prince got the attention and the acclaim that he was needing. Purple Rain came out, he became a big deal. And then years later, Prince died. And the Warhol Foundation made the first one was a Prince photograph that was manipulated in purple, and then they made Warhol Foundation made they might have made another magazine cover, but they made a poster that was out of the same body of photographs and sold them, sort of as a remembrance. And this one was orange background. And so the photographer sued the Warhol Foundation, and then the Warhol Foundation sued the photographer to try to straighten out who had the rights to do this and why. The Supreme Court heard the case, and I'm not going to venture into what they were thinking, although listening to the 9 of them go on about Prince and Warhol, it's like they were on another planet. I have no idea. Apparently, Justice Thomas had heard of Prince and he was a fan, but otherwise his questions were, I don't know, naive, maybe. We'll see what happens. We're going to get a decision on that, on fair use and what's going to be reasonable. But the substitute for the original, whether the consumers of the work are going to be confused, or was there money change? Money doesn't matter. Whether it was a penny or $100,000, the amount of money that you get or don't get for the copies is secondary to the fact that it was done, and we'll see where it goes. Where do I want to end up with this? That is not an infringement of Mickey Mouse. It's more of a comment. Is it a free speech issue? We don't know. I have this poster framed in my office. It's from the Comic Book Legal Defense Fund. And I'll leave you, because it is May the 4th, with that thought. You have rights in the work that you create. You also have a right to comment on, and I add that I believe as creators of work, that you have an obligation to comment on, take stuff, turn it around, turn it on its head, to do what you need to do. If we don't continue to use free speech and fair use, it will wither, and we will end up having 9 people on the Supreme Court that don't seem to get it, why that's important. Just my opinion, but I'm over here and saying it. The Supreme Court of all people should get that it's important in America to have a free conversation and free debate and free speech, and we'll see where that goes. Comments? Anything? Was that too much? Was good? Do you feel empowered to steal? To appropriate? Yes.
Yeah, so I have a question, going back to your slide where you talk about registering.
Yeah.
Copyright. I'm, I guess, a little bit confused for those of us who are in public access. Isn't our work already, like, free for use, or?
If we work for the government, like a lot of us, we work for our city and produce content for our city. Is that fair use? Right away?
Another person asked me that once. Buzz Aldrin said, I went up on the moon, I took pictures, the taxpayers paid for the ride, who owns the photographs that I took? In that particular case, the photograph of the moon with the Earth in the background belongs to all of us. It was work done by the government, and it was by design in the public domain. You should have something clear in your contract with government about who owns the stuff that we're creating. If you're a camera that's set up in the city council chambers, I would probably argue that you don't own the stuff that's there. But I wonder what your contract says about what you own and what you can do with it. And if it's not clear who owns it, if it's not in your contract who owns it, if it's not clear in the government policy who owns it, the unclarity, and I know this sounds like trouble, but I'm leaving the state in 2 days and you'll never find me. If they don't talk about it, then I believe that you own it, and somebody should exercise. If they don't exercise control over it, somebody should be clear about who has control over it. Now, probably if you're just setting up a camera in the city council chambers, it's not you. It's not the station. I would guess that that's not the case. But if you're in as a news reporter, and I can tell you a story about a news reporter that was invited to a political event where George Clooney was sitting next to a guy that would later become president, and a AP photographer took a photograph of George Clooney and the guy that later became president of Obama. And it was the only time that George Clooney was cut out of a photograph because the other one was more interesting. And they made a poster of Obama with hope under it. And the AP reporter who never gave up his copyright in that image was able to resolve some things with Shepard Fairey for stealing his artwork because it was never clear. So it's worth having a discussion. If there's no big deal, then there's no big deal. But if somebody says something, or if the work is appropriated and used in a way that you don't feel good about, you should get some clarity before you need to get some clarity. You call the city attorney, or not just call them, maybe put it in writing, and bring a witness and a nun to have this conversation, so you have this is what you said and we're going to rely on it, because you want to do that before something weird happens. Yeah.
So I have a question, not as a public employee, but as a public citizen. Can I register a work, or to copyright a work before it exists? Can I go on the website and fill out the form and click submit, and then hit go live on my webcam and put it out on
No one has ever
Facebook or
asked me that question. How do you protect?
copyright it before it exists?
Well, you can't copyright it before it exists, but now this is like angels on the head of a pin argument. Because, because if it goes through your lens out into the world, even though the amount of time between here, your machine, and the world is like that, it does exist before it's made published. I don't know, how do you protect that? I would say probably you want to be hard to put it back in the can, but I would say the next thing you want to do after you've got this nice live stream recorded is register it that day or later, a few minutes later. It won't cover the time that you've let it out into the public. It's an interesting argument. The courts haven't looked at that. I think the way the law is now, that you wouldn't have control over it until you've registered it. But that comes up a lot with people that are doing recording, and then it becomes newsworthy minutes later. And if you can still assert that you have the rights to it, and you still demand to be paid for it, but I don't know whether you would have enough control to stop somebody. The Copyright Office doesn't work that fast, which I guess is good. But I don't know. That's a good. Now I have to go look that one up. Oh, one more thing I want to, because somewhere there's a handout. Two more things I want to say. One. Oops. Bound by law, You can find a digital copy of this. It's written by 3 IP professors. I think they were from Duke. The one that was my friend that's dead was the lead author on it. It's called Bound by Law. His name was Keith Aoki. This is good. You should have digital copies of this and pass them out in your center or make it available. It's online. It's under a Creative Commons license. I forgot the other thing I was going to say. Oh, it's about the new CCB. It's not the contractors board. There is a kind of a copyright, almost like a copyright mediations, where you can bring a case to be, so it's ccb.gov. You can try to use a copyright claim. It's a part of the Copyright Office. You get 3 copyright experts to help you resolve an issue. That's the one where to file the case, you will need a copyright registration, but I think it's only $40 to file the case and start it in action. You can look at the CCB and see the cases that have been filed. This is brand new, started last August. It's being used to help resolve who owns things and how do you work things out. So I'm going to write a note to those guys about your question. I think that's a really interesting one, but that's a new tool that's available to us. And then I'm done with my hour. Thank you.